Good morning, everyone, and welcome to the Autumn Legacy webinar. My name is Angela Chapman, and I have the pleasure of being and serving as the President and CEO of the VGH and UBC Hospital Foundation. It's a beautiful autumn day outside, and many years in the past, we've had this gorgeous autumn day for the Autumn Legacy event, but it's normally been one where we get together, and we get together on the UBC golf course in that lovely room. This year, we've had to break with tradition, as most people have had to break with tradition this year, and we're having a webinar. So I want to welcome you. I know from looking over the list of people that registered that we have a number of board members and committee members. We have many of our Heritage Circle members, people who have supported the foundation for many years. So I want to say welcome to you all. And before I begin, I just want to start with acknowledging that we are currently, I believe Richard and myself and Gary, we're all on the ancestral, traditional, and unceded Aboriginal territories of the Coast Salish peoples, including the Musqueam, the Squamish, and the Tsleil-Waututh. And we're very grateful for their tending and caring for the land on which we live and work. I see a number of you have joined us today who are part of our Heritage Circle, and I want to give that a special shout out. You're a special group of supporters who have generously planned a future gift to the VGH and UBC Hospital Foundation to advance healthcare for all British Columbians. Last year, we received over $6 million from the state and other planned gifts. It's a very important part of the impact that we have on healthcare every year. These legacies have allowed us to channel vital funds from most urgent needs through state-of-the-art equipment to research and to improving patient care and patient comfort. So I want to thank you all for your letting us know that you have made plans for us in your will. As many of you know, VGH and UBC Hospital Foundation is the philanthropic engine for health innovation and transformation in British Columbia's healthcare. From our origins as a foundation supporting Vancouver General Hospital some 40 years ago, we are BC's largest, most specialized teaching hospital here at VGH. We have now grown into expertise that enables us to support specialized care not only in the hospitals, but through Vancouver Coastal Health Research Institute, GF Strong, and out into the community. I'd like to extend a warm welcome to Richard Weiland, who is joining us today, partner at Clark Wilson. We are so very fortunate to have his expertise here today. And Gary Siegel, who is our chair of our board of directors. I'm going to hand it over to Gary in a minute to introduce Richard. Before I do that, just a couple of things to keep in mind as we move forward this morning. You'll have an opportunity to ask Richard any questions that you have in a Q&A after his presentation. Please use the chat box, which will only be seen by the presenters today. For your questions. So please put your questions into the chat box. You're going to be muted through the entire webinar. So that will be the best way for you to direct your questions, and they will be curated and brought forward for Richard later on in the Q&A session. This session is being recorded. And for those of you who are on the phone, I do have to apologize because there will be some slides. We'll make them available to you later, and I apologize that you're not able to access those if you're on the phone, but hopefully, I know Richard is a fantastic speaker. He'll give lots of context to explain things, and you are welcome to pose your questions as well. So over to Gary Siegel, our wonderful board chair, became the board chair this year. Gary, over to you.
Thank you so much, Angela. Hi, everyone. I am Gary Siegel. In addition to being a principal of the Kingswood Group of Companies, I'm also proud to be the board chair at VGH and UBC Hospital Foundation. Welcome to this Autumn Legacy webinar. I would like to take this opportunity to express my sincere gratitude to all of you who have generously committed to leaving a gift in your will, making a gift of life insurance, or designating your RSP, RIF, or TFSA to VGH and UBC Hospital Foundation. Your legacy gifts certainly help ensure our healthcare teams are equipped to have the best chance at saving lives, both now and well into the future. Your gifts today provide us with long-term sustainable funds to make a difference in the lives and communities of future generations. Legacy gifts are really important to the health of our hospitals because they fund many vital and life-saving programs. This includes, as mentioned, most urgent care needs, and things like other areas such as Parkinson's, leukemia, bone marrow transplant, GF strong rehab, prostate research, spine research. List goes on, really. These gifts touch so many different aspects of healthcare, and the impact is truly immeasurable for the patients who benefit from them. One of the great things in my role is I get to see, meet, and thank firsthand the many supporters who choose to help our healthcare system. Unfortunately, in these times, don't get the chance to personally see you on this call today, but I look forward to in the near future being able to do that in person. But the people we're helping, some are patients who are helping support us, some are patients and their families, grateful for the excellent world-class care they received. Some of them are the ones who simply care about and want to contribute to better healthcare services in our community. So at VGH, we are fortunate to have one of the best healthcare systems in the world. This would not be possible without your support. Because of you, our medical teams are able to provide the best treatment possible to each and every patient who comes through our doors. Because of you, we have access to the state-of-the-art medical equipment, and we can comfortably create a long-term plan to meet patient demand for both emergency and scheduled surgeries in the future. Thank you all for your vital impact to the foundation. We look forward to have your continuous support in the future. Now it's time for a featured speaker this morning. He's a trust and estate practitioner and partner at Clark Wilson, an adjunct professor at Peter A. Aller School of Law at UBC, and a frequent expert guest speaker in the media. Please welcome Richard Weiland. Thank you.
Well, thank you for that introduction, Gary and Angela. And thank you everybody for joining us today. It's such a pleasure to be part of this event. This Autumn Legacy event, as Angela said, is something that has a history to it. And I have previously participated in this event, both attending and in 2 years in the past, in 2010 and 2016, I have been a speaker at this event. I've always enjoyed being part of it, and so there's a little bit of a disappointment today in that I don't get to meet with you all face to face and to be able to see you, and especially I enjoy the chatting with people after the lunch. And I'm also going to miss the fantastic lunch that the UBC Golf Club always puts on for us. But I'm very grateful. I'm grateful that we do have this technology available to us, that we're able to still meet in this way. And I'm also grateful for the strong turnout today from foundation supporters. I always, in my practice, I love working with you people who are supporters of the foundation. When I'm working with people who have a connection with the UBC and VGH Hospital Foundation, you carry a sense that you have benefited from being part of a community, and a part of a community that includes expertise and the fantastic expertise that we have in our healthcare system in Vancouver. You acknowledge that you've benefited from that, and you have a commitment to contributing back to the community that you've benefited from. And that for me as a practitioner makes my work rewarding as well, to be able to be part of that and to work alongside you. So for the next 15 or 20 minutes, I am going to be speaking to you on the general topic of building a secure estate plan for uncertain times. My intention today is not to cause any greater anxiety than perhaps you are already feeling based on the events of the last year, but just from a very practical and pragmatic perspective, I want to talk about some of the changes that have happened in our world in the last 6 to 9 months, how that has impacted on estate planning and things that I'm hearing from my clients and working with my clients. And then what are some practical steps that you can take to ensure that during these times of greater uncertainty, that your estate plan in particular is one area where you can feel like it's secure and it's been well thought out and well laid out. Okay, so let's just start from a very high level, talking about the far-reaching effects of COVID-19. We're approximately 9 months into this pandemic now, and the significant government actions and restrictions were in late March, so we're about 6 months into the period where it's had a significant impact on our lives and what we do. How is this impacting us? Well, it's changing life in so many ways for us. It has changed our lives. Top of the list, of course, is the primary health concerns. People are concerned with will I become ill from this virus? How will that affect me? Will I survive if I do get it? If I do survive, what will the long-lasting health implications be for me? What about my family members? Perhaps you're somebody who has a family member who is in an at-risk category, or you are yourself. So these primary health concerns are at the top of people's minds. The government restrictions and actions in response to COVID-19 have also caused a significant change in people's lives, and everybody is feeling this. Isolation, people are more isolated. They have less connection with the people that they would normally be coming into contact with, and that can be it can be really anything. Whatever groups it was that you were participating in before, many of those activities have stopped in the last 6 months, or they've turned into virtual events, but we don't get the same sense of social connection from virtual events, although we, as I said before, we are thankful that we do have that. All of this leads to mental health impacts for many people. I see this certainly in working with my clients. Some people who perhaps had mental health concerns before they've been exacerbated by the situation. Or people are experiencing new anxiety that perhaps they didn't have before. We also see this even just as an employer. My law firm is, we employ about 300 people in total, and just from that perspective, many of the people on our teams are, we're helping them to work through the process of the mental health impacts of COVID-19. Then we get into all of the financial impacts. So there have been, across the country and around the world, many people have lost their jobs as a result of the disruption. People's incomes have been affected, and for those, many of my clients operate businesses, and in anything that's in the health, or sorry, not health, the entertainment, hospitality, those sectors, and also any brick and mortar retail sector businesses, they've been severely impacted. There are other sectors where either there's been less impact, or in some sectors it's they've actually seen an increase in their business depending on what they do. But all of it leads to a great deal of uncertainty. Building from that and compounding on that is stock market volatility. In March, we saw one of the most significant drops in the stock market in many years. Now, over the summer, the stock market has largely recovered to the point where it was early in the year, but this leaves many significant questions about what will happen next. Is the recovery real? Is it something that we should be concerned about another significant decline? And so these are things that that again cause people to ask questions and have concerns. And then we have significant action by the federal and provincial governments, lots of different relief programs. That's not my topic today, so I won't get into all of it, but it does raise the prospect in people's minds, and this is what I am hearing from my clients, is are we concerned about the amount of money that the government is spending? We recognize that it's necessary to carry us through this time, but what does this mean in the future in terms of, we know in the past when governments have run large deficits, there comes a point where it has to be paid for. What's the plan of the government to pay for that, and how, if that's through increased taxes, how will that affect me? So with respect to estate planning in particular, I would say, in my experience, compared to the conversations that I was having with people a year ago, many of my clients and contacts, they have more time on their hands to be thinking about their estate planning, or they did over the summer at least, while there were more restrictions in effect. There's also, combined with that, there's a greater sense of urgency to act. And that urgency to act can stem from the primary health concerns that I talked about. It can stem from the wealth changes and the changes in the stock market. It also comes in some cases because of concerns of possible tax changes. So we're seeing a huge uptick in interest in people wanting to look at their estate planning, revisit their estate planning, and more of a motivation to act on it. Than we've seen at times in the past. At the same time, the estate planning process, it can be hindered by the current situation, in that often part of the estate planning process, which I'll talk about in a few minutes, involves having meetings with family members or close friends to discuss and have discussions about your plans and so on. That's made more difficult. And then probably equally significantly, there have been barriers to easily access professional advisors. So if you previously would have sat down to have a meeting with your financial advisor or meet with your lawyer or meet with your accountant, and if your preference is to have those meetings in person and when in a way where more information can be conveyed more easily, it's going to be more difficult now to set up those meetings. It may be possible in some cases, but many of those meetings will be shifting to either phone conversations or online meetings. So if you are in this situation, and if you are somebody who's thinking, perhaps I'm somebody who should be looking at my estate planning and making sure that it's up to date, what are some practical steps that you can take during this time? I think where you want to start with is just taking inventory of who are the people who you have in place who can help you with this process. Nobody should go through the estate planning process on their own. You're going to make better decisions and more informed decisions if you have the help of knowledgeable people around you. That might be close family members. It might be, again, your close friends. But do think about when you're inviting family members into the process, think about whether the family member in particular that you're thinking about, are they somebody who is going to be able to be neutral in this process, or is this a person who is going to have a conflict of interest or a potential conflict of interest? So, for example, there may be a situation where somebody's working on their estate planning. They have 2 children, but the 2 children don't get along with one another and never have been able to. Well, there are ways that we can address that in the estate plan. But if you choose to involve one of your children in the estate planning process and not the other, you can do that. In some ways, it might make sense to do that. And yet, you have to be aware that in and of itself, involving one of the 2 children in the process but not the other is going to cause potential for greater conflict. So then moving outside of that circle of family members and friends, who are your existing professionals that you have in place? Perhaps you have a long-standing relationship with an accountant, or maybe it's a financial advisor. For some people, it's a private banker. It may even be a lawyer. So start with those trusted professionals that you have in place, and perhaps have an initial conversation with them and just say, hey, I've been thinking about revisiting my estate plan. Are there any things that you think I should think about in this process? In particular, financial advisors and private bankers, if you have somebody in that category, many of them have a process that you can engage in where they will review your estate plan for you and provide you with suggestions and comments. This is not the same as going and getting advice from a lawyer, but it can be very helpful in that it can help you to gather the information that you have already, gather the information about the plans you have in place already, and they can help you to identify perhaps where there may be gaps that need to be addressed. And the benefit of this is that often their cost structure is such that this may be a service that they provide to you for either a flat fee or perhaps no additional cost to the fees that you're already paying to them. Then you'll want to think about who else are you going to need to assist in this process. And maybe you have all of the people in place already. Maybe you need to add to your team. If you are adding to your team, for example, if you're needing to bring in a lawyer to help you with your documents, think about the expertise. And obviously I could be seen to have a vested interest in saying that, but what I will say is be realistic about whether your situation is something that's very simple, which everybody thinks their situation is simple, but not everybody's situation is simple. And then match your situation with somebody who has the appropriate expertise. So if your estate really is very simple and you're leaving it to one child and there's not going to be any fighting over it, it may very well be that you could work with somebody who is familiar with wills and estates, but maybe doesn't have it as their main focus of their practice. However, if you are in a situation where it's anticipated that there could be conflicts within your family or relating to your estate, or you have unique tax situations, perhaps you're a US citizen, or you have assets in the US, or you have assets with significant capital gains, then seek out the expertise that will be able to help you solve your problems in a knowledgeable way. So ask people questions about, how long have you been working in this area? What percentage of your practice is focused in wills and estates? What industry groups are you members of, etc. Next, the next thing that you want to do is to be identifying your estate priorities, and that's, what are the most important things that you want your will or your estate plan to accomplish? Are you wanting to provide for, typically providing for a spouse, or if you have any people who are dependent on you, that will be the primary concern. Next would be if you have children or grandchildren, or perhaps other relatives, and you have a desire to advance them in life through your estate, that may be another priority. Providing a benefit to the community, what I mentioned at the outset, you may have, if you're part of the call today, you probably do have a desire to provide a benefit to the community through gifts that can make an impact. What might also be important to you, you may have specific ideas about your personal articles, your artwork and your jewelry and so on, and your household belongings and where you want them to go. You might have funeral wishes that you want to express in your will. Those are some of the things that might be important to you. And then a crucial question, who should manage your estate? And that may be It may be that a family member or a combination of family members, or perhaps close friends or business associates, maybe that's the appropriate choice. Or perhaps you don't have somebody who fits neatly into that category and you might be looking at professional options. But this is not only about thinking about what happens after you die and the distribution of your estate. Another crucial part of the estate planning process is thinking about what happens if I become incapacitated. If you come to the point where you are no longer able to manage your financial affairs and your healthcare decisions, you need to have a plan in place for that. Who should be the person in that situation who you would want, who you would trust to manage your financial affairs? And that is everything from paying your bills day to day, taking care of banking, but also bigger decisions like selling property, changing your investment strategy, for example. So what, in addition to the question of who, you want to think about what should that person that you're giving that power, what should they have the power to do? Well, obviously, they're going to be managing your assets for your benefit and making sure that you're taken care of financially. But for example, if you're in a regular practice of making gifts, maybe annually you make a gift to VGH and UBC Hospital Foundation, and you would like that to continue. Well, you need to specify that in your power of attorney, because if you don't, your attorney may not have the power to continue making those gifts. On the flip side, are there any things that they should be restricted from doing? So, I'll give you another example here. Maybe you have a fine collector's automobile, and you really want that on your passing to go to your niece who has a real interest in that car. Well, you don't want your power of attorney stepping in and saying, oh, they're not going to drive that car anymore, I'm going to sell it, because you want to make sure that that's going to go to your niece. So that's all part of that incapacity planning. Very closely related question, who will make medical and personal care decisions for you? And again, not only who, but do they know what your wishes are around medical care and personal care? So once you've addressed some of those initial questions, you want to have an assessment of your current plan. And you may be doing this yourself, but you may very well be involving your other advisors in this process. Does your current plan meet your objectives? What could cause problems? Maybe it's some of the documents are incomplete, or maybe they're out of date. Maybe you have documents sitting in a folder at home, but you've written a bunch of notes on them saying, oh, I don't want that anymore. I want to change the amount of that gift. And you've kind of thought in the back of your head, well, maybe that wasn't sufficient, but it's in the file. People will know that's what I want. That's a good sign that it's a time to update your estate plan. Do you anticipate legal challenges from family members? Are you somebody who has a second marriage or a blended family? Who are your legal representatives, your executors, your attorneys, and are they still the right people if you named them, let's say 10 or 15 years ago? So then all of that builds to, okay, now we're going to be building the new plan. So you want to give your instructions to your lawyer. That's going to come through questionnaires that the lawyer will send you and ask you to fill out and send back. Then there'll be follow-up emails and conversations, maybe on a video call like this or on the telephone. You'll review your drafts. You'll have an opportunity to ask questions and have them answered. And then you'll get to the point of signing your documents. Signing documents during COVID, this has been an area where there have been some changes, and we've had to adapt a little bit. So the gold standard for executing your documents is you come to the lawyer's office and you sign your documents in front of the lawyer. The lawyer will witness on your will and some other documents. It may need a second witness, so then another person will be brought in to act as a second witness. By doing it that way, we can make sure that everything is done correctly, and we have it all properly witnessed. But that may not be possible. You may not be able to go to the lawyer's office. Another possibility is if you can't leave your home, is that perhaps the lawyer can visit your home. We've had some meetings where we sit outside with people at their tables, and we execute the documents there. If that's not possible, perhaps you're more restricted in terms of who can see you. We can maybe arrange to have the documents signed before two people who are not lawyers, but we give you very careful instructions on how to do that. And then finally, the last option is, and this is a change in the law, it is possible now to execute wills and other documents by video conference like this, where you're signing the document and I am meeting with you, or another person is meeting with you electronically, and we go through the document together, and then you sign and I sign as a witness on an identical copy of the same document. It's a possibility. It's something that the process is a little bit cumbersome, but it is there to be used in cases, especially where somebody maybe has an active case of coronavirus and they really can't see anybody else. Once that's done, congratulations. Make sure that you inform your key people, your executor, your attorney, and so on, and then review your plan every 3 to 5 years. So if you're somebody who is in this category, your planning is all complete, congratulations. If you're not, I hope I've given you some things to think about. So now we will move into the question and answer period.
Hello, everyone. Thank you, Richard. That was a really very interesting presentation and wonderful context for our current situation. Gary, would you like to ask the first question today?
You know, it would be my pleasure. And again, thank you, Richard, as well. It's a very important subject and very complicated, lots of issues to consider, as you pointed out to all of us. So let me kick off one pretty straightforward question, I think, for you. I'd like to ask, what are the advantages or disadvantages of naming a company as an executor?
Yes, thank you, Gary. That's a good question. So I just touched on that very briefly in my presentation. So, you know, the question of who's going to act as your executor, it's something that you should think through carefully. And one of the options that's available to you is to appoint a professional trust company. These are companies that are in the business of acting as executors and trustees. And so, you know, the benefit of appointing a trust company is, well, there are a few benefits. One is that it's their business. They do this all the time and they know what to do. So as compared to appointing somebody in your family who perhaps has never administered an estate before, a trust company will generally be very efficient in carrying out the process of administering the estate. They're going to be familiar with the process and with things like how to account to the beneficiaries that might be a bit of a mystery to a layperson, although they can figure it out with assistance. Another advantage of a trust company is that they are neutral. So if you're in a situation where you have battling family members, and doesn't matter who in the family you appoint, the other ones are going to give them a hard time, then you might say, well, actually, why don't I just cut all of that out by appointing a trust company, and you know, everybody will see them as a neutral person, and they can just focus on getting the job done. A common objection to appointing a trust company is, oh, but don't trust companies charge a lot of money for acting as executor? Well, they do, of course, charge a fee for it. What's not always understood, though, is that individual family members who act as executor and trustee will also charge a fee for acting as executor. They're entitled to charge a fee, and most of them do. So, you know, you're going to be paying a fee one way or paying a fee another way. You know, perhaps you should consider whether paying a professional trust company to take on the role would be better in your circumstances. But there's no one right answer.
Okay, interesting. Thank you.
Thank you. Thanks for that, kicking us off, Gary. So I just want to remind everybody who's listening in, please put your questions into the chat box and we'll bring them forward for Richard. And in the meantime, I am going to ask you a question that we've sort of thought about here. What are some of the opportunities, Richard, that you want to highlight for people about saving taxes in their estate planning?
Yes, that's a very also a good question. It's a very big question because the tax planning opportunities will really depend on the person's circumstances. But things that we commonly see, you know, one of the big opportunities for saving on taxes is often with RRSPs, because those generally are subject to tax, fully taxed as income on the death of the RSP holder, subject to available exemptions. So there's RSPs can be rolled over to a spouse, and that would typically happen. RSPs can also, if that spousal rollover isn't available, RSPs can often make a great gift to a charity. So what happens then is that the RSP is still subject to tax on death, but the donation of the RSP proceeds to the charity also creates the donation tax credit, which can be used to offset the taxes. Other opportunities for saving on taxes often focus on situations where somebody has significant capital gains in their assets, or perhaps they have a private company where they ran a business for a number of years and it's increased in value, or they've held real property that is increased in value. And there's some planning that we can undertake around that to try and minimize the impact of tax on the person's death.
Great. As you alluded to in your session, you talked about kind of family relationships and you know, their involvement in advising or how to manage those relationships as you're negotiating your estate plans. What if in the case that there is a desire to leave, you know, your funds to a child, but not say to a common law partner? Mm-hmm.
Yeah, that's a question that comes up fairly frequently, where my clients are indicating to me, yeah, we want to leave our assets to our children, but we have a concern with, you know, maybe the relationship that one of them's in, and what's, you know, is it going to continue? Is it not going to continue? And the concern is around, you know, will this person who will, you know, in the event of a breakdown of the relationship, will this person end up walking away with a part of our family wealth? Obviously, it's a real concern. So that's a concern that is addressed in a number of ways. You know, typically the best way is to have the children or the beneficiaries in question enter into marriage agreements that specify what would happen on a breakdown of the marriage. But we do find that in many cases, there's some resistance to that as a solution. So another thing that can be looked at is, can the child share, rather than going to them outright, can it be left for them in trust, where you have somebody else managing the funds for the benefit of the child, but it's not all coming into their hands? And you know, this is a complicated area. Family law is a complicated area. I don't want to leave the impression that a trust solves everything, but it can be a part of an overall plan to keep the assets protected and within the family.
Well, very much related, we have a question that says, could you please touch on joint spousal trusts?
Yes, okay. So I didn't get into you know, a lot of technical details in my presentation, but joint spousal trusts relate to some of the things that I said. So many of the people listening will have heard somewhere about either alter ego trusts or joint spousal trusts, and they're closely related to each other. What they are, ultimately is it's a planning tool that is an alternative to a will. So you can take all or some of your assets, and rather than having your will dictate what happens to those assets after you pass away, you can take those assets and put them into a alter ego or joint spousal trust during your lifetime. These trusts are available to people who are over the age of 65. There's no tax consequences to the assets going into the trust, and then the trust provide for what happens to those assets after your death. The benefit of doing that, as opposed to just using a will, is that those assets are not part of your estate legally, and therefore, number one, they're not subject to probate fees, and number two, they're not subject to claims that people may have against your estate and the assets of your estate. So sometimes there may be an asset protection reason for using a trust like that. Again, something that you would want a specific advice on as to whether this may be appropriate in your situation.
Great, thank you for that. There's another question, does a RIF count as an RSP?
Does a RIF count as an RSP? RIFs and RSPs are different but related. So RSPs convert to RIFs when you know the RSP is the savings plan and the RIF is the pension plan where you're withdrawing from it. So yeah, I think what the question is getting at is, are they taxed in the same way that I was speaking about before? And the answer is yes. So whatever's left in your RIF at the time of your death will be subject to tax as well. And you can also designate beneficiaries on a RIF the same way that you can an RSP. So many of the same tax planning opportunities available there.
Great, thank you. What is enduring power of attorney?
Enduring power of attorney. So in my presentation, I talked about planning for incapacity, and an enduring power of attorney is a document that that you can use to appoint somebody to manage your financial affairs for you. And in fact, the enduring power of attorney, it becomes effective as soon as you sign it, but the enduring part of it is that it continues on in effect, and so the person still has the powers to act for you if you're incapacitated. So despite the fact that you might lose capacity, they can continue to act for you, and then the law governs, you know, that they have to act in your best interest. So it's a planning tool for managing financial affairs in the case of incapacity.
So I suspect that we probably see this more often now as people live longer. Do you have some recommendations about stretching your money out? So a lot of people may have planned that, you know, they retire at 65 and they make that run until 85, but then they find themselves living to 100. How do you keep stretching that money out?
That's a really good question. I would say that question is perhaps pulling at the edges of my expertise. What I would suggest, if a client asked me that question, I would put them in touch with a good financial advisor, and because really it's an exercise of you know, there's only a certain number of levers that you have. You can either try and increase the income that's coming into you, or you can try to manage your expenses, right? So it's going to be a combination of those things. It's not typically, that's usually not the lawyer addressing those questions, but a financial advisor, that's exactly what they do. And so you should be working with a good financial advisor.
I think that makes good sense. What happens when someone dies without a will? Yes,
unfortunately, it happens too often still. And what happens when somebody dies without a will? There's a scheme in our legislation that says how your assets are divided when you die without a will. And essentially it goes to your closest relatives, but there's an organized way that the law sets that out. So if you have a spouse and no children, it would all go to your spouse. If you have a spouse and children, it would be divided between your spouse and children. And then, moving on from there, if you don't have either of those, it would go to your closest relatives as the law defines them.
There was an interesting program on CBC this last weekend that involved a child kind of speaking to her parents who did not want to create a will for fear that it was kind of setting up some karmic timeline for their passing. And so, sometimes we do have a bit of this taboo about speaking about wills as part of kind of bringing on our inevitable demise. It was interesting. It was interesting from that perspective, but I thought there was something that came up in there that the parents were sharing, that they had property in other countries, and therefore that complicates things. So properties in California, and I believe it was properties in Eastern Europe. What sort of advice do you have on those kind of complications within estate planning?
Well, yeah, I mean, you've raised a couple of good things there. One is the difficulty sometimes around having these conversations, and there can be personal and or cultural factors that play there. The second part of your question is related to, when there are assets in different jurisdictions. And I would just say that creates definitely a higher need to engage expertise to help you with the planning. We deal with multi-jurisdictional estates frequently, and it really depends on the jurisdiction that you're dealing with. Some of them, like the UK, for example, and other Commonwealth jurisdictions, have legal systems very similar to ours, and so they're relatively easy to work with. The US is a little bit different, and then when you move to like civil law jurisdictions like France or other places in the world, they have more like mandatory distribution schemes. They don't recognize wills in the same way. It can get fairly complicated. So definitely it is something that has to be worked into the discussion.
So two things related to that, I'll just quickly ask you. One is, you have to be quite, selective of your legal counsel in that case, that they have that expertise. I'm guessing not everybody can do that.
Yes.
Okay. And then secondly, does it matter where you choose which jurisdiction to create that will in? So, I mean, if you have sort of an option that you have 3 different places or 3 different countries, does it make a difference which one is the kind of overriding law in that?
Short answer is yes. And the slightly longer answer is that typically what we're looking for in those cases is to establish what jurisdiction would be considered legally the domicile of the person. And domicile is a bit of a tricky concept, but at the core, it's what jurisdiction do you have the closest ties to, and also a long-term intention to reside in. So that's typically where we would be starting. And then that may be where the master will is made, and then you may end up making separate wills in the other jurisdictions in order to deal with the assets there. And then in addition to the legal questions, there's the related tax questions, right? So where on the person's death, where are the tax liabilities going to be arising, and how do those things fit with one another, so that you don't end up in a situation where the estate is paying tax in 2 different jurisdictions on the same economic gain.
Excellent. Well, I think we've covered a fair bit of ground, not only from your presentation, but in those questions. So thank you so much, Richard. We really appreciate having your expertise here to join us today. And so I want to extend also my thanks to those who are on the webinar, who are our supporters, our Heritage Circle members. We are so grateful for you keeping us in mind and ensuring that part of your legacy is an impact on healthcare for all British Columbians going forward. If we were together at the UBC golf course, we would be having all of our staff members stand up, and particularly Charlene Taylor, who is responsible for this area of gift and estate planning. I do want to say that in addition to seeking legal counsel, One of the reasons you might want to reach out to us and discuss your plans is that you may want to have information about particular programs that you can have an impact on, wording that is necessary for your will to make sure that that is that your intention is put into that will in the way that you hope that it will be fulfilled. So Charlene is definitely your person on our staff, but we have a whole host of staff that you may already be engaging with, and we would be delighted to have those conversations with you. So on behalf of all of us, I want to say a great big thank you to everyone, a very big thank you to Richard. Thank you for taking the time today to learn more about this important area, particularly in this year, and we appreciate everyone's time today. Thank you again. Thanks everyone. Thanks Richard. Bye now.